Thank you all for coming, as always, and supporting this event. This is the first year we're doing this based upon, speaking to so many families and members of the community with individuals with disabilities, that this type of event is so important. The amount of information that we gain and can generate through conversation here today and the different presentations you'll learn about is very crucial to making sure that you're developing appropriate planning and otherwise. So the topic that I will talk about is guardianship and other protective arrangements. Obviously, Tom and Ellen have spoken about some of the includability of guardianship in what you're planning for. But I want to take a big step back just for a minute. So I've been with the firm for approximately 16 years now. Prior to coming to the firm, I spent a couple of years during law school in the court system. I was an intern, and then I was clerking in the probate part, which in New Jersey is the division of the courts that hears these types of matters, i.e. guardianship, conservatorship. Back when I was first clerking, it was amazing because guardianship was basically a paperwork submission. Individuals would submit their files and the judge would look at it and say, somebody needs a guardian, somebody doesn't need a guardian. The process was basically as easy as that. The problem was we weren't really thinking through all the legal logistics, all the things we're talking about today, the family dynamics. What all really does it entail to have a guardian appointed? The transition of that has been both a positive and somewhat as the response to negatives that have occurred in New Jersey and around the country. You've had a lot of individuals who have utilized their protective arrangement authority to exploit individuals with disabilities, either financially or through abuse. And you've also had a lot of individuals around the country who just simply don't understand the nature of why we need these protective arrangements. All the things we're talking about today, from general estate planning to conservatorship to guardianship, which we're going to talk about in our presentation here, are forms of protective arrangements. All the speakers here today are talking about how do we protect someone? How do we make sure we have a comprehensive plan in place to protect them? What are the services we need? Who are the professionals we need? Et cetera, et cetera. I will tell you that one of the primary issues that we have gotten into recently, and for those of you who may read the news, a lot of people call me and say, what are your thoughts on the Britney Spears conservatorship? How should we be interacting with that? Because this is crazy. Her dad exploited her and did this, et cetera, et cetera. I'm like, well, first off, it's a little different, but it's a much more high profile case. In the past few weeks, I'm sure many of you have seen, who saw the movie The Blind Side? Michael Oher, the left tackle NFL football player, and the family, the Tahoes, who basically got a conservatorship in Virginia over him. And there's been a lot of press about what happened with the movie. And this is giving conservatorship, guardianship a bad name, if you will. People think this is why, oh, well, I don't want that. I have to make sure that we are protecting somebody. That is not the standard, right? There's always outliers, unfortunately. The goal is, we're going to talk about today is, what do we need to be very mindful of, and why is it important to consider all of our options from conservatorship to guardianship, et cetera? So, types of protective arrangements. Parents do voluntary estate planning. An individual can do voluntary estate planning. Tom and I often talk about, especially a lot of our cases, what is most appropriate? What should the family consider when they're really, discussing an individual and the needs for that protection? And the simple answer often is, it depends. If everybody had the crystal ball, we wouldn't be here today. If I could sit here with my ball and say, this is the person's whole life, this is what the needs are going to be, this is how much it's going to cost, this is when I'm going to die, when they're going to die, it's a much easier timeline. We don't have that, right? We wouldn't be here. So the goal is to put all the resources in place to make sure that we can protect ourselves and the individual that we are entrusted with their care of. So as Ellen referenced, one of the primary changes that has occurred in New Jersey, especially the past couple of years, is the promotion of limited guardianship versus plenary guardianship. So a plenary guardian pretty much takes over all decision-making for an individual. In most instances, especially the cases we deal with, except for maybe limited reservation of rights, a lot of individuals will need some form of plenary guardianship because they may not be able to make decisions that directly impact their health, their well-being, their financials, et cetera, et cetera. As Ellen mentioned, the statute is very clear on this, however. The goal is to make sure the individual who may have even a plenary guardianship is involved in their decision making, that they are able to self-direct and be involved as much as possible in whatever the care plans are, whatever the decisions are for them. We recognize that some individuals, their care needs are so beyond the scope of them participating that we really just need a plenary decision maker. But for the individuals, especially as we have such an increase in diagnosis of autism, other forms of developmental delay, mental illness, as these issues are coming more and more to the forefront, we recognize that a lot of these individuals may need assistance, but it may be something that they can still reserve certain rights or participate more in their decision making. So we want to make sure that we're going through all the different options. If we are looking at a limited guardianship, which we're going to talk about the process in 1 minute, we have to make sure that limiting the guardianship does not detrimentally impact the individual's rights. So often, and the internet is both a blessing and a curse for those of us who practice this way, because individuals come in and say, Mr. Ordog, I read on the Google that the guardianship should look like this. And I'll say, again, first off, that might be a different state. It may be a very different situation. There's a lot of parent advocacy groups. There's a lot of individual advocacy groups who are really supporting alternatives to guardianship right now. Those of us in the guardianship field, we fully support autonomy. I fully support other types of protective arrangements if the result is the protection we need. Okay? That's the key answer that we need. So people say, let's go general scope. What are the overviews of guardianship? So there are two types of primary guardianships. We'll start with New Jersey, and other jurisdictions call them different things, but they're generally the same. You have guardianship of the person. This would be related to issues, residential considerations, medical considerations, healthcare decision-making. Those all deal with guardianship of the person. When you're dealing with guardianship of the property, you're dealing with the individual who would have control over assets. There's been a real shift in New Jersey that most of the jurisdictions do not like to appoint a guardian of the property if the sole asset is Social Security. I, and some of my very close colleagues, disagree with this to some degree simply because there are often times that financial institutions or the banks or otherwise, they still want to see that designation to make sure they're able to communicate with a parent or a loved one about the financials, even if it is someone who may be representative payee for Social Security purposes. So some of the courts in New Jersey, if you work with an attorney or file an action on your own, and the courts say, we're not going to appoint you as guardian of the property, just be very mindful of that, because this is an ongoing debate that we're having around the state and amongst the members of the bar. Individuals will often say to me, who should the guardian be? Well, a lot of parents are very frustrated with the guardianship process. If it's a child turning 18 who has been disabled for 17 years and 364 days, they say to us, why on the 365th day when my child turned 18 do I now have to go through this legal procedure to basically have someone tell me and inspect what I have done or what I plan to do with my disabled child, right? It is a tough part of this process because at 18, we become an individual of majority and we now have legal rights. You know, technically under HIPAA, some of these other organizations, they say when a child turns 18, we have to communicate with them directly. We understand that you've been advocating, that you've been the parent for the past 17 years and 364 days, but now you have to take that formal legal step. That's a hard decision for a lot of people because they say, well, let's just see what happens, right? But the protection we need to afford to these families and to these individuals most often outweighs the wait and see approach or just saying, we're not going to do anything at all. A lot of individuals will come forward and say, we're just going to have our child sign a power of attorney because that should get us by. I'm asked often, recently a reporter from, I think, the Broward County Times called me to ask me about why can't disabled people just do powers of attorney? And I said, well, again, it's a loaded question. I'm happy to schedule a further time because these national stories with Brittany and Michael Oher, they generate individuals' interests, and I'm sure people want to talk about this stuff. A power of attorney is a competent person giving another competent person the right to assist them. It does not give us plenary decision-making authority or the ability to force a decision on someone. So if I have an individual with a disability or a need who does have limitations, we have to be very mindful of what legal, healthcare, residential, school issues might arise that as our child turns 18 and is now a legal adult, will that power of attorney be sufficient? Often we get appointed by the court to serve as court-appointed counsel in these guardianship matters. And they are often difficult, especially as we are dealing with individuals who are very high functioning and want to have rights and don't want their parents to take over decision making. And the court often says, what is the least restrictive alternative? Is it a power of attorney? Is it a conservatorship? Is it a guardianship? And I often have to talk to the doctors. The doctors play a key role in this because they want to be able to understand what is this person's ability to reason, make informed decisions. Can they participate? If they go to a doctor and they say, Johnny, you need knee surgery. You tore a ligament in your knee. Are they going to understand? Are they going to get scared? They don't want the surgery? Are they going to fully understand, yes, doctor, I understand that I have an injury. I need you to do the surgery. Because in theory, these are the problems we deal with. What in that moment would the person's reaction be? Because a lot of the individuals who have needs, they immediately look to their parents anyway and say, what do you think I should do? Should we consent to this? So basically, you want to make sure that legal authority is in place. I was saying to Tom this morning, I was reminded of a case a few years ago where I got appointed. The family struggled with power of attorney versus guardianship. Their daughter went to a local high school, was extremely high functioning. Most individuals would not have known that she even had disabilities or had any mental issue. They went forward with the guardianship. The week after the guardianship got finalized, she was dared by a few of her friends to steal something at a local store. She got arrested, and at 11 o'clock on a Saturday night, my phone rings and it says, police department on it. And I'm like, oh boy, I thought I did something wrong, but no, that's... So I answered the phone and they say, the parents are here. They want you to explain to us what happened last week because they said there's a guardianship in place. Their daughter just stole something from a local store. We are prepared to charge her. And I explained the whole process to the police, what had happened, what the court adjudicated. And they said, thank you for your time, et cetera, et cetera. Parents called me about an hour later and they said, the officers did not charge her because we had guardianship. If she only had the power of attorney, they would have charged her because there was no adjudication. So with that guardianship in place, the officer said she did not have the requisite capacity to knowingly steal something. Now that's an extreme answer, but these are things that we deal with that I don't sleep much as it is because I have 3 small children, but I often wake up and think about my clients, what makes the most sense for them? What is the best protection that they need? And what is it for these families? Because we're talking a minute, but for those of you that are here today, you're showing a dedication to learn more, understand the process. The problem with so many of the families is my clients often think they're going to live to 150. They're never going to pass away. They're going to take care of their kids' needs, which is a wonderful thing to think. The problem is what happens when these legal issues come up. The more and more, the way the medical community is responding to this, the way the banks are responding to this, they want to see more legal authority in place because they're worried about themselves. So it has made us transition a lot of these decisions to maybe more, despite what Tom may say, and I agree with Tom, the goal is to not have guardianship if we don't have to, but we're seeing more and more of the need for the legal protection. Why does that also frustrate a lot of families? The court system. The court system is backed up. The court system is, the judges are very dedicated to this area of practice. They are very mindful and they've really come a long way in understanding the right questions to ask, that this is really something that is the families have to deal with. But one of the things that I say at a lot of the seminars, especially to family support groups, is guardianship, and the judges always say, they love when I say this when I say it in court, it's a responsibility, it's not a right. A lot of families will say, I have to be my child's guardian, or I have to be my loved one's guardian. And you say to them, well, why is that? Well, I'm the parent, I'm the sibling, my parents are gone, et cetera, et cetera. That's not always the case because this is a responsibility. It does come with it another level of fiduciary involvement that you have to be very mindful of, that you're willing to accept. The other thing that New Jersey really has kind of changed in the past couple of years is the process, which we'll talk about in 1 second. But just to give an overview, up until a few years ago, basically you got guardianship and you filed what was called an annual report with the surrogate just to say we still need guardianship, and that was about it. For those of you who are in this process or about to enter this process, there's now a guardianship monitoring program that the state has enacted. There are volunteers who go to the surrogate's office. They review the annual reports. They make recommendations if the court needs to bring anybody in to talk about any issues, et cetera, et cetera. So a lot of parents say to me, again, we don't want more people involved in our lives. This is designed this way because unfortunately there's been a number of cases, mostly in North Jersey. The South has protected us for the most part, of unfortunately exploitation, abuse. They want to make sure that they are monitoring these programs. And of course, if you read the actual legislation when they did the guardianship monitoring program, it was designed to make sure if parents didn't understand something or need additional services, that somebody could point them in the right direction. Okay, so there is a rhyme or reason to this process. So people say to me all the time, if I want to consider guardianship, what is the first thing I need to be mindful of? The first issue is in New Jersey, guardianship cannot be established for an incapacitation until the individual turns 18. We have a lot of individuals who come in and say, my child was diagnosed, they're 12, 13, 14 years old. We need to get guardianship. We simply cannot do it before the age of 18. Again, for an incapacitation. 2 doctors, they can be from the same practice group, but 2 doctors have to certify to the incapacitation. In most instances, when you're dealing with somebody who has made the decision to go for guardianship, getting the doctors is not an issue because the individual has needs that the doctors are aware of and they're fully supportive of this. If you're on that cusp of, I think we need this for my child with a disability or other loved one with a disability, but it's on that realm of will they dispute it? Do we need a limitation on it? Please do not have the podiatrist sign the doctor's forms. You want a neurologist, you want the general practitioner, somebody who knows the individual a little better. We recently had a podiatrist sign a doctor's evaluation saying the person was incapacitated, and I basically called the dad and I said, podiatry, that's the specialty? And I'm like, is there a new form of podiatry that I'm not aware of? And they said, no, it's my son's foot doctor. And I said, okay, well, I'm sure the judge will love that. So again, the case was a no-brainer case. The issue is just that be mindful of that as you're thinking about doctors. Financial considerations. A lot of individuals are not aware, and I know Emily and is going to talk about it later, what public benefits are out there. So a lot of times individuals are not aware that you can get income if you apply for it. So you have to make sure that in the process of why we're doing guardianship, is that a consideration and are we going to go for it? The courts have expanded what they want to hear in the complaint to also include a care plan. This has become, I think, one of the topics that has caused maybe the most ire the past couple of years outside of having the guardianship monitoring program is the parents will say, we're trying to get by day. How do we develop a care plan the court's going to accept? The courts are not saying you have to have a detailed, day-by-day report. They just want to have an idea of what the plan is going to be, especially for individuals who are 18 or still in school. Obviously, there's a more consistent plan. What the courts do not want to hear, and this has become, I think, where a lot of the providers who are doing life care planning and assisting families has become a wonderful blessing. When they age out of school, our plan is to have our child just stay at home and play on the iPad and do whatever. That's not what the courts want to hear because they want to make sure that people are still challenging these individuals, getting them into OTC programs, getting them into work programs, doing whatever else is out there to enhance their quality of life, because it's unfair that they age out of school and all of a sudden there's nothing for these individuals to do, right? So a lot of parents, I know there's a program down the shore, there's a retired special needs teacher who started a day program herself that parents send their children to. There's about 15 people in her program now. I understand there's more and more of these popping up. And again, people are just saying, we want to make sure besides the respite you guys may need for some of the care that you're giving 24/7, that there's other activities, there's other events going on. A lot of families also, and this is, I think, they tell people when we do this, we should go to law school for, poli-sci, pre-law, everything. I tell people all the time that I should have gone for psychology because most of my day is spent talking to families about, the nature of the psychological part of this. And it's tough because they all think they're in it by themselves. They say like, I have a disabled child and, we don't know what to do. There's support groups. There's all these services that the state has, all these organizations. Getting in with the right resources and professionals. Tom talks about it takes a team. That's what it does. And we recognize that individuals may be hard pressed for time. You have other family obligations. We recognize this takes so much out of your individual time in a day and that mental worry of what's going to happen today, tomorrow, 10, 15 years from now. We recognize all that. That's why it's so important to have life care plans done. That's why it's so important to start this process early with just general planning, both financially with your legal documents. Basically, a complaint gets filed with the court. The court, by legislation, the individual who is alleged to be incapacitated has an attorney, usually it's a local member of the bar, appointed for them to basically review the situation, interview the proposed guardians, interview the proposed ward, and make recommendations to the court on the guardianship. Two primary questions that the judge wants answered. Number one, is the person incapacitated? Number two, who's the best guardian? And then some other ancillary considerations of what's the care plan going to be, what other services we have to make sure the individuals are mindful of, et cetera, et cetera. There is a hearing. Most counties will hold a hearing, especially because they want the parents to understand, again, it's a responsibility, not a right. We go to court, there's testimony taken. Typically, they rely upon the certifications of the doctors in the form that they are presented, which is written. Rarely do we have oral testimony from the physicians now. We have oral testimony from the family, explaining why the guardianship is necessary, explaining what the plan is, explaining that I am willing to serve in this capacity, file my annual reports, et cetera, et cetera. There are a lot of post-judgment considerations that may come up. We have a number of matters that may occur related to financials or healthcare decisions and things like that. So the courts basically retain jurisdiction over the ward and the parents. You have to do your annual reports. If the person passes away, you have to notify the surrogate, et cetera, et cetera. Overall, though, as much as we do a lot of work in a lot of the courts, the courts are pretty much out of your lives other than you submitting your annual reports. If there's an issue, they are there to help us. So the process itself, it's complicated, but you get through it. You just have to think through a lot of the logistics to make sure you are presenting a case to the court that is consistent with what your needs are, what the needs of the proposed ward are, if it's a plenary or limited guardianship, and who are the actors going to be. One of the biggest issues that comes up, and I think Tom and Ellen both have stated it so succinctly, and I'm kind of going to end on this general topic because it kind of covers the last few slides. Involving other members of the family. A lot of times the plan is, well, if mom and dad pass away and they're the guardians, our other child is just going to take on the guardianship. Two things. One, the courts will not appoint a successor guardian in that capacity typically until the moment arises, because they say we don't know in time and place where the sibling may be. Can they even be a guardian? If the person's a doctor with 3 kids 20 years from now, they may not be the best individual to be guardian to their sibling. But also for those who are in this process or have done this process, informing the individuals who could be the potential guardian. What are the diagnoses? What are the treatment plans? What is the overall desired outcome that the parents want for this child so that that individual is involved enough to taking over? The life care planning and the letter of intent process has been more of a recent thing. And so many of the families say, we wish we had done this sooner because we are much older now. Our child is 30, 40 years old. They probably have 20, 30 more years. We might have 10 to 15 left. Our daughter, who we believe is going to take over, even though we tell her, oh, Johnny had this or, this happened, she is not really versed enough in the overall scope of what's going to happen. So it does require generational consideration, advocacy, et cetera, et cetera. Residential placement, and Ellen brought up a very good point about, there's a lot of misconception of what the residential options or limitations are. I'm not saying it's great out there. There's a ton of places to go, But the more families who actually go and see some of these facilities, if there's no other option, they feel a little more comfortable, because this is probably, out of all the things we talk about in guardianship, the families will say, what happens when we're not here anymore? What is, we're just going to assume that somebody's going to go live with another loved one. We have to be very mindful of, working this process. And the courts are really starting to say more and more, where is the residential plan going to lead us? Because the courts are concerned, I'm going to be dealing with a post-judgment application that the parents have passed away. A sibling is going to come in and say, Judge, I have no idea what to do. And the judge can't just say, well, do this or that. So getting in the system, making sure that options are available early is very important. I put the common diagnosis because a lot of individuals think like, somebody to get guardianship has to be really just, cerebral palsy, Down syndrome, cerebral palsy, Asperger's, autism. They continue this list of common diagnoses that we're seeing require guardianship for. And this is always the process with the court system of a lot of time educating them on a lot of these new conditions or new diagnosis or new treatment plans or how we are dealing with the individual's level of autonomy. I thank you for coming. If there's any questions, you can get more information at BegleyLawGroup.com, including articles on guardianship. And again, I'm always available to talk about this stuff. If you have a family support group, we do a lot of family support group presentations on this stuff because it is a complicated process. We're lucky that there are some online resources now and a lot of state agencies who can help with this process and give guidance, but it does always make sense to at least talk to professionals who have experience in this because it can become a daunting task at times. Thank you.